Section 92, subsection 4 of the Trademarks Act provides two different grounds for non-use removal of a trademark registration. Paragraph A refers to situations where the owner did not intend in good faith to use the trademark in Australia at the time of the application and has not, in fact, used the trademark. Paragraph B refers to the situation where the owner has not used the trademark for a continuous period of 3 years. Prior to 24 February 2019, Section 93, subsection 2 specified that a 3 years non-use type removal application could not be filed until a period of 5 years had passed from the filing date in respect to the application for registration of the trademark. After 24 February 2019, Section 93, subsection 2 specifies that a 3 years non-use type removal application cannot be filed until 3 years have elapsed from the date the particulars of the trademark were entered into the register under Section 69. This essentially means 3 years from the date on which the trademark registration is granted. Thus, if a trademark application proceeds to grant in, say, 9 months, a removal application can be filed after 3 years and 9 months from the application date, instead of having to wait for 5 years under the old version of the legislation. The change to Section 93 was brought about by Part 3 of Schedule 1 to the Intellectual Property Laws Amendments, Productivity Commission Response Part 1 and Other Measures Act 2018. Item 46 of the schedule reads as follows. Section 93 of the Trademarks Act 1995, as substituted by this part, applies to a non-use application in relation to a trademark if the filing date in respect to the application for the registration of the trademark is on or after the day this item commences. This appears to be intended as a transitional provision, but instead of saying that the old version of Section 93 will continue to apply to trademarks with filing dates before the commencement date, it merely says that the new provision will apply to trademarks with filing dates on or after the commencement date. It is, of course, obvious that the new provision will apply to trademarks with filing dates on or after the commencement date, and there is no need for a transitional provision to tell us that. What the transitional provision doesn't say, but presumably did intend to say, is that the new provision should not apply to trademarks with filing dates before the commencement date. As far as the Trademarks Act is concerned, the old wording of Section 93 has been completely replaced by the new wording. Unless you happen to be aware of the existence of Item 46 in Schedule 1 of the Intellectual Property Laws Productivity Commission Response Part 1 and Other Measures Act 2018, you would have no way of knowing that there was intended to be a transitional provision. Nonetheless, the Trademarks Office Manual of Practice and Procedure states that the new time period only applies to trademarks where the application for the registration of the trademark has a filing date on or after 24 February 2019.